Hello and welcome. I'm Graham Stott from Lexis PSL Private Client. I'm here today with Tony Millson, the Head of Private Client at Royds, to discuss the recent case of the Royal National Institute for the Deaf and Turner, re the estate of Dorothy Whelan deceased, which concerned an application to prove a will in solemn form and which turned on the issue of due execution. Tony, would it be fair to say that disputes of this nature concerning wills are on the increase?
I think so, Graham, and this was a very interesting case which we'll talk about in a minute, but both involving charities and those not involving charities, there do seem to be more disputes these days. Maybe it's the economic climate, maybe there's more money around to be fought over, but there are more disputes.
Royds was recently involved in this case, and in which 1.8 million was left to charities, but the bequest was challenged on the basis that a will made over 15 years later superseded the terms of the will to be proved. Do you want to explain the situation behind the case?
Yes, this goes back to 1982 when Mrs. Whelan, indeed, and her then husband made a will with Royds, leaving the four charities, Marie Curie, Action on Hearing Loss, RNIB and the Royal Institute of Cancer Research as the four beneficiaries. What then happened was Mr. Whelan died in about 1999. Mrs. Whelan became ill with dementia, and an attorney looked after her affairs for the last 12 or 13 years of her life. It transpired, though, that a will had been made in 1999, as you said, Graham, and when we first got involved on behalf of the charities, we were very concerned about the later will, which seemed to us to have been incorrectly executed, particularly because, and this was a great help to us, both the witnesses were adamant that they'd not witnessed Mrs. Whelan's signature. So that gave us a huge advantage. Notwithstanding all that, it did get to the High Court, and eventually Judge Behrens found in favour of our will, but it was a long struggle.
And in a case such as this one, what are the factors that the court are likely to consider in reaching a decision?
Well, I suppose we started off slightly on the back foot, despite what I just said, because the assumption is that the later will supersedes the earlier will. And that's certainly the case where the will has been duly executed and on its face appears to be validly executed, and the document contains a full attestation clause, which in brackets a will prepared by a solicitor would do. This 1999 will was a homemade will, and there was considerable doubt as to the way in which it had been executed. There were different handwritings on it. There's no doubt at all 3 or 4 people had played a part in preparing the will, and ultimately, as I've said, the 2 witnesses say they hadn't witnessed it anyway. And we had a handwriting expert, about which I'll say more in a minute.
And what are the main difficulties clients face when they're involved in a will dispute such as this?
It is very unpleasant, bluntly. All litigation is. And it can be acrimonious. There's a strain on the family, there's a strain on relationships. It may, being mercenary, it may not be possible to get all the costs back, even if you're successful. And of course, we're talking about a long period here, 1982 and 1999, whichever date you look at, it's quite a long time ago, and there's not much contemporaneous evidence. We were extremely lucky to repeat that the 2 witnesses were still alive and hale and hearty. And allied to that, of course, there is a long time lag. Court proceedings, by and large, or to get to court, takes a long time.
And what can people do in an attempt to reduce the risk of a will being contested at a future time?
I'm clearly biased here, but I would say go to a professional. The dangers of the DIY route are just too costly, in my view. Even as a professional, you've got to make sure you're given clear instructions, and that what you eventually draft is clear of any ambiguity at all. If a will is professionally drafted, the solicitor would assess the capacity, the mental capacity of the testator as to whether he or she had the capacity to make a will, and there was some doubt about that in Whelan, though it didn't affect the issue in this particular case. Certainly, if anything is going to be put in a will out of the ordinary, we advise clients should leave notes with the wills explaining what they've done. They don't have to, I hasten to add, it's their business, but to avoid some disputes, that would be helpful. I don't think it would have helped here. And more controversially, and again, this wouldn't have helped in this particular case, have an open discussion with the family to explain what you're going to do and why you're going to do it. You don't have to do that, and I say that's slightly controversial, but it may avoid many disputes. I say this one I fear was going to happen come what may.
Tony, thank you for joining us. So, another case highlighting the perils of DIY wills and stressing the importance of why clients should approach a solicitor to prepare a professionally drawn will. Thank you for joining us.